Mr. Speaker, I should point out that since this government has been in office, there has been no case which has been caught by the Pratt and Morgan provisions of a matter not being completed within a 5-year period, as it has been caught in Jamaica and in some other jurisdictions. In other words, our judicial system, it works in a manner not to trigger the Pratt and Morgan limitation. What in our situation has been the problem in carrying out the death penalty is the question of the ruling in a series of cases, and I'll make reference to them, by the Privy Council and also by the Court of Appeal in our jurisdiction, that the death penalty is not mandatory for murder. No. The first case in which this was decided in respect of the death penalty not being mandatory for murder, the appeal cases of Peter Hughes of St. Lucia and Newton Spence of St. Vincent and the Grenadines. These cases can be found in, they were heard together as number 12, were reported together as number 12 of the United Kingdom Privy Council, number 12 UKPC. Newton Spence, Hughes and Spence. Mr. Speaker, the case of Daniel Trimingham came to light. And the court, I want to just read this. The Privy Council says, the law can be expressed in relation to the death penalty. The approach to impose the death penalty can be expressed in two basic principles. And I'm reading from paragraph 21 onward of that judgment. The first has been expressed in several different formulations, but they all carry the same message, that the death penalty should be imposed only in cases which on the facts of the offense are the most extreme and exceptional. The worst of the worst, or the rarest of the rare. In considering whether a particular case falls in that category, the judge should of course compare it with other murder cases and not with ordinary civilized behavior. The second principle is that there must be no reasonable prospect of reform of the offender, and that the object of punishment could not be achieved by any means other than the ultimate sentence of death. The character of the offender and any other relevant circumstances are to be taken into account insofar as they may operate in his favor by way of mitigation and are not to weigh in the scales against him. Before it imposes a sentence of death, the court must be properly satisfied that these two criteria have been fulfilled. That is, the worst of the worst or rarest of the rare, and the person is incapable of reform, taking into account a set of circumstances. They go on to say, and I read in now paragraph 22, Mr. Fitzgerald, that is to say the lawyer for Compey, Trimingham, Mr. Fitzgerald readily accepted, the lawyer for Trimingham at the Privy Council, readily accepted that the appellant's crime, that is Compey, Dick Trimingham's crime, was a brutal and disgusting murder. involving the cold-blooded killing of an elderly man in the course of a robbery. He contended, however, that is, Compe's lawyer, contended, however, that it fell short of being in the category of the rarest of the rare. He submitted that the killing did not appear to have been planned or premeditated. And although the manner of the killing was gruesome and violent, there was no torture of the deceased, nor prolonged trauma or humiliation of him prior to death. I'm reading what the judges of the Privy Council said, you know. And we may recall the facts that the prosecution proved that Daniel Dick Trimingham had disemboweled Mr. Brown and had severed his neck. I noticed that Minister Miguel is shaking because she knew Felix Brown, also known as Ding, popularly known as Ding in Mespo. This is what they went on to paragraph 23 and said. Remember, I just said what the lawyer for Daniel Dick Trimingham said. Paragraph 23. This is not what the Privy Council's lords said. Their lordships accept the correctness of this contention. They accept what Trimingham's lawyer said. They go on to say, it was undeniably a bad case, even a very bad case of murder committed for gain. But in their judgment, it falls short of being among the worst of the worst, such as to call for the ultimate penalty of capital punishment. The appellant Dick Trimingham behaved in a revolting fashion, but this case is not comparable with the worst cases of sadistic killings. Apparently, this is a common, ordinary garden killing. Bad, terrible, revolting, but not comparable to the worst cases of sadistic killings. Their lordships would also point out that the object of keeping the appellant out of society entirely, which the judge considered necessary, can be achieved without executing him. In other words, keep him for life. They go on further. Paragraph 24. This conclusion makes it unnecessary for the board to consider the factors relating to the character and personality of the appellant, to which the content of the medical reports, if admitted, would be material. Nor do they propose to express an opinion on the other grounds of appeal against sentence advanced on behalf of the appellant, save that they feel obliged to draw to the attention of the prosecutors once again the principles set out in paragraph 10 and 11 of the judgment of the Privy Council in the case of Randall versus the Queen, 2002, United Kingdom Privy Council, UKPC 19, regarding the standard of conduct to be expected of them as ministers. I'm sorry, I said that it was Ding. Ding gave the evidence. Felix Brown is Ding. Bertie Brown is the person who was beheaded and dismembered. I'm sorry. Because Ding himself gave graphic testimony about what happened to Bertie Brown.